ಅವರು ವಿರೂಪಾಕ್ಷಾಚಾರ್. ಹಲೋ ಹಲೋ ಹಲೋ, ಕೇಳಿಸ್ತಾ ಇದೆ ಅಂದ್ಕೊಳ್ತೀನಿ. ಎಸ್, ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಮೈಸೂರು ಪೆನ್ಷನರ್ಸ್ ಕಮ್ಯೂನಿನ ವತಿಯಿಂದ ತಮ್ಮೆಲ್ಲರಿಗೂ ಸ್ವಾಗತ. ಇವತ್ತಿನ ದಿವಸ ಈ ಸಭಾಂಗಣದಲ್ಲಿ ಕಮ್ಯೂನಿನ ಸದಸ್ಯರು ಬಿಟ್ಟು ಬೇರೆ ಯಾರೂ ಇಲ್ಲ, ಎಲ್ಲರೂ ನಮ್ಮವರೇ. ಹಾಗಾಗಿ ನಾವು ನಮ್ಮೆಲ್ಲರನ್ನೂ ಸ್ವಾಗತಿಸೋಣ. ಚಪ್ಪಾಳೆ ಬರಲಿ. ಆ ಚಪ್ಪಾಳೆ ಹೊಡೆದ್ರೆ ನೀವೆಲ್ಲರೂ ತಮ್ಮನ್ನು ತಾವು ಸ್ವಾಗತಿಸಿಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಅರ್ಥ. ಇದು ನಮ್ಮ ಕಮ್ಯೂನು ಈ ತರನಾದ ಕಾರ್ಯಕ್ರಮವನ್ನ ಮಾಡ್ತಾ ಇರುವಂತಹ ಏಕೈಕ ಸಂಸ್ಥೆ. ಮರ್ಜರ್ ಮೊದಲು ಕೂಡ ನಾವು ಮೀಟಿಂಗ್ ಮಾಡಿದ್ವಿ. ಆಗೊಂದು 500-600 ಜನ ಬಂದಿದ್ರು. ಮತ್ತೆ BRS ತಗೊಂಡವ್ರಿಗೆ ಟ್ರೈನಿಂಗ್ ಪ್ರೋಗ್ರಾಮ್ ಕೂಡ ನಾವು ಅರೇಂಜ್ ಮಾಡಿದ್ವಿ. ಮತ್ತೆ ಈ ತರನಾದ ಕಾರ್ಯಕ್ರಮವನ್ನ ಮಾಡ್ತಾ ಇರ್ತಕ್ಕಂಥ ಏಕೈಕ ಸಂಸ್ಥೆ. ನಾನು ಕಾರ್ಯಕ್ರಮವನ್ನ ಪ್ರಾರಂಭ ಮಾಡಿದ್ಮೇಲೆ ನಾನು ಇಂಗ್ಲಿಷಲ್ಲಿ ಮಾತಾಡ್ತೇನೆ. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ಇದು ಯೂಟ್ಯೂಬ್ ಲೈವ್ ಇದೆ. ಬೇರೆ ಆರ್ಗನೈಸೇಷನ್ನಿನ ಮತ್ತೆ ಬೇರೆ ಊರುಗಳಲ್ಲಿರ್ತಕ್ಕಂತಹ ನಿವೃತ್ತರು ಕೂಡ ಈ ವಿಡಿಯೋನ ನೋಡಲಿಕ್ಕೆ ಸಾಧ್ಯತೆ ಇದೆ. ನಮ್ಮ ಉದ್ದೇಶ ಏನಂದರೆ EAB ಅಂದ್ರೆ ನಮ್ಮ ಸಹವರ್ತಿ ಬ್ಯಾಂಕಿನ ಎಲ್ಲ ನಿವೃತ್ತರು ಮತ್ತೆ ಸಹವರ್ತಿ ಬ್ಯಾಂಕಿನ ಎಲ್ಲ ಉದ್ಯೋಗಿಗಳು ಭಾರತೀಯ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕಿನ ಜೊತೆ ವಿಲೀನವಾದ ನಂತರವೂ ಸೇವೆಯಲ್ಲಿದ್ದು ಅಥವಾ ಸೇವೆಯಲ್ಲಿದ್ದು ನಿವೃತ್ತರಾಗಿರ್ತಕ್ಕಂಥ ಎಲ್ಲರಿಗೂ ನಾವು ತಲುಪಬೇಕು ಅನ್ನೋದು ನಮ್ಮ ಮೂಲ ಉದ್ದೇಶ. ಈ ಕಾರಣದಿಂದ ನಾವು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನು ಮಾಡ್ತಾ ಇದ್ದೇವೆ. ಈ ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷತೆಯನ್ನ ನಮ್ಮ ಕಾರ್ಯಾಧ್ಯಕ್ಷರಾದಂತಹ ಸಿದ್ಧಗಂಗಯ್ಯನವರು ವಹಿಸಿಕೊಳ್ತಾ ಇದ್ದಾರೆ. ನಮ್ಮ ಅಧ್ಯಕ್ಷರಾದಂತಹ ಕಾಣಶ್ರೀ ಅವರಿಗೆ ಮೊನ್ನೆ ಗುರುವಾರದ ದಿವಸ ಶಸ್ತ್ರಚಿಕಿತ್ಸೆ ಆಗಿರೋದ್ರಿಂದ ಅವರು ಈ ದಿನ ಬರಲಿಕ್ಕೆ ಆಗಿಲ್ಲ. ಅವರು ಬಹುಶಃ ನಿನ್ನೆ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿರ್ತಾರೆ. ಹಾಗಾಗಿ ಅವರು ಬಂದಿಲ್ಲ. ಮತ್ತೆ ನಾನು ನಮ್ಮ ಕಾರ್ಯಾಧ್ಯಕ್ಷರಾದಂತಹ ಸಿದ್ದಗಂಗಯ್ಯವರು 4 ಮಾತುಗಳನ್ನ ಹೇಳಬೇಕು ಅಂತ ನಾನು ಕೇಳ್ಕೊಳ್ತೇನೆ. ಈಗ ಮಾನ್ಯ ಶ್ರೀ ವಿರೂಪಾಕ್ಷಾಚಾರ್ ಅವರನ್ನ ವೇದಿಕೆಗೆ ಕರೀತಾ ಇದ್ದೀನಿ. ಅವರು ಪ್ರಾರ್ಥನೆ.
ನನ್ನ ಹೆಸರು ವಿರೂಪಾಕ್ಷಾಚಾರ್ ಅಂತಂದು ಹಗರಬೊಮ್ಮೆ ಬ್ರಾಂಚ್ ಹಗರಬೊಮ್ಮೆಯಲ್ಲಿ ನಾನು ರಿಟೈರ್ಮೆಂಟ್ ಆಗಿದ್ದೇನೆ ರೀ. ಮೊದಲೊಂದಿಪೆ ನೀನಗೆ ಗಣನಾಥ, ಮೊದಲೊಂದಿಪೆ ನೀನಗೆ ಗಣನಾಥ, ಬಂದ ಕಷ್ಟ ಕಳೆ ಗಣನಾಥ, ಮೊದಲೊಂದಿಪೆ ನೀನಗೆ ಗಣನಾಥ, ಹಿಂದೆ ರಾವಣನು ಮದದಿಂದ ನಿನ್ನ ಪೂಜಿಸದೆ, ಹಿಂದೆ ರಾವಣನು ಮದದಿಂದ ನಿನ್ನ ಪೂಜಿಸದೆ, ಸ್ಕಂದರಾಜ ಗಣನಾಥ, ಮೊದಲೊಂದಿಪೆ ನೀನಗೆ ಗಣನಾಥ, ಆದಿಯಲ್ಲಿ ವಿಷ್ಣುರಾಯ ಸೇವಿಸಿದ ನಿನ್ನ ಪಾದ, ಆದಿಯಲ್ಲಿ ಧರ್ಮರಾಜ ಪೂಜಿಸಿದ ನಿನ್ನ ಪಾದ ಸೇದಿಸಿದ ರಾಜಗಣನಾಥ ಮೊದಲೊಂದಿಪೆ ನಿನಗೆ ಗಣನಾಥ ಮಂಗಳ ಮೂರುತಿ ಗುರು ರಂಗವಿಠಲನ ಪಾದ ಮಂಗಳ ಮೂರುತಿ ಗುರು ರಂಗವಿಠಲನ ಪಾದ ಬಂಗನ ಪಾಲಿಸೋ ಗಣನಾಥ ಮೊದಲೊಂದಿಪೆ ನಿನಗೆ ಗಣನಾಥ ಮೊದಲೊಂದಿಪೆ ನಿನಗೆ ಗಣನಾಥ. ನಮಗೆ ತಬಲದಲ್ಲಿ ರವೀಂದ್ರ ಕಲಾಕ್ಷೇತ್ರದಲ್ಲಿ 23 ತಾರೀಕಿಗೆ ಕಲಾ ಸೇವರತ್ನ ಅಂತಂದು ನಮಗೆ ಬಿರುದು ಕೊಟ್ಟಿದ್ದು ಸರ್. ನಿಮಗೆ ಸರ್
ಈಗ ದೀಪ ಬೆಳಗೋದ್ರಿಂದ ಕಾರ್ಯಕ್ರಮ ಪ್ರಾರಂಭ ಆಗುತ್ತೆ. ನಾಗೇಶ್ ವಿ ಎನ್ ನಾಗೇಶ್ ದಯವಿಟ್ಟು ಬರಬೇಕು.
ವಾಸು ಅವರು ದಯವಿಟ್ಟು ಮಾನ್ಯ ನಿವೃತ್ತ DG ವಾಸು ಅವರು ಕೂಡ ಬರಬೇಕು ಅಂತ ಕೇಳ್ಕೊಳ್ತೀನಿ. ಬನ್ನಿ ಚಂದಣ್ಣ. ಸೊ ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಫ್ರೆಂಡ್ಸ್. ಸೊ ಇವತ್ತು ಒಂದು ವಿಶೇಷ ಸಭೆ, ಆ್ಯಕ್ಚುಲಿ ನಾಟ್ ಫಾರ್ ಆಲ್ ಮೆಂಬರ್ಸ್, ಓನ್ಲಿ ದೋಸ್ ಹೂ ರಿಟೈರ್ಡ್ ಫ್ರಮ್ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ, ದಟ್ ಈಸ್ ಫ್ರಮ್ 1/4/2017. ಕಾರಣ ಏನಂದರೆ SBMಲ್ಲಿದ್ದಾಗ SBI ಬೇರೆ ಇತ್ತು, ಅವಾಗ ನಮ್ಮ ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸು ಎಲ್ಲ ಇತ್ತು. ಈಗ ಮರ್ಜ್ ಆದಮೇಲೆ ನೋಡಿ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಏನಂತಂದ್ರೆ, ಮರ್ಜ್ ಆದಮೇಲೆ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಮೈಸೂರಿನವ್ರು ಎಲ್ಲ ಅಸೋಸಿಯೇಟ್ ಬ್ಯಾಂಕ್ಸ್ನವ್ರು ಮರ್ಜ್ ಆದಮೇಲೆ ಆ್ಯಕ್ಚುಲಿ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಸೌರಾಷ್ಟ್ರ ಆ್ಯಂಡ್ ಇಂಡೋರ್ನವ್ರಿಗೆ ಮರ್ಜ್ ಆದವ್ರಿಗೆ SBI ಆಫ್ ಮಾಡಿರೋರಿಗೆ ಅವ್ರಿಗೆ ಫ್ರಮ್ ದಿ ಡೇಟ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅವ್ರಿಗೆ PF ಕೊಟ್ಟರು. ಬಟ್ ಈಗ 1/4/2017 ಏನು ಮಾಡಿದ್ರು, ಓನ್ಲಿ ಫ್ರಮ್ ದಿ ಡೇಟ್ ಆಫ್ ಮರ್ಜರ್ ಕೊಟ್ಟರು. ಆಮೇಲೆ ಅವರಿಗೆ ಆ್ಯಕ್ಚುಲಿ ಏನಂದರೆ 40-50 ಇತ್ತು ಏನೋ ಪೆನ್ಷನ್ನು,
ಅಪ್ ಟು ಸ್ಕೇಲ್ 3 ದೇ ಯೂಸ್ ಟು ಗೆಟ್ 40%, 50% ಫುಲ್ ಬರ್ತಾ ಇತ್ತು. ಆ ಸ್ಕೇಲ್ 4 and above ಓನ್ಲಿ 40% ಬರ್ತಾ ಇತ್ತು. ಸೊ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ದೇ ಆರ್ ಗೆಟಿಂಗ್ ಥರ್ಡ್ ಬೆನಿಫಿಟ್, ಮೂರನೇ ಬೆನಿಫಿಟ್ ಅವ್ರಿಗೆ ಸಿಗ್ತಾ ಇತ್ತು. ಈಗ ಅದನ್ನು ಜಾಸ್ತಿ ಆಯ್ತು, ಈಗ ಅವ್ರದ್ದು 40-50% ಆಯಿತು. ಈಗ ಆಲ್ಮೋಸ್ಟ್ ಅವ್ರದ್ದು ಪೆನ್ಷನ್ ರೆಗ್ಯುಲೇಷನ್, ನಮ್ಮದು ಪೆನ್ಷನ್ ಬರುತ್ತೋ ಅದೇ ಪೆನ್ಷನ್ನು ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾದವ್ರಿಗೂ ಬರುತ್ತೆ. ಆದರೆ ಅವ್ರಿಗೆ 3 ಬೆನಿಫಿಟ್ಸ್ ಇದೆ, PF, ಗ್ರ್ಯಾಜುಯಿಟಿ ಆ್ಯಂಡ್ ಪೆನ್ಷನ್. ಬಟ್ ನಮಗಿಲ್ಲ, ನಮಗೆ ಓನ್ಲಿ ಪೆನ್ಷನ್ ಆ್ಯಂಡ್ ಗ್ರ್ಯಾಜುಯಿಟಿ. ಅದೇ PF ನಮ್ಮ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಕೊಡ್ತಾರೆ, ಬ್ಯಾಂಕ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಕೊಡೋದಿಲ್ಲ. ಸೊ ಅದಕ್ಕೆ ಈಗ ನಾವೇನಂತಂದರೆ ವಾಟ್ ಮಾಡಿದವ್ರಿಗೆ ಈಗ ಎರಡು ಕೇಸ್ ನೀವು ಆಗ್ತಾ ಇದೀವಿ. ಒಂದು ಕೇಸ್ ಆಲ್ರೆಡಿ ಫೈಲ್ಡು. ಒಂದು ಏನಂದರೆ ಈ ಮರ್ಜ್ ಆದಾಗ ನಮ್ಗೆ ಆಪ್ಷನ್ನು ಸರಿಯಾಗಿ ಕೊಡಲಿಲ್ಲ ಅಂತ. ಏನಂದರೆ 15 days ನೋಟಿಸ್ ಕೊಡಬೇಕಾಯಿತು. 15 days ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಫಸ್ಟ್ ಆಫ್ ಆಲು. ಆಮೇಲೆ ನಾವು ಮರ್ಜರ್ ಬ್ಯಾಂಕ್ದು ಏನಿದೆ ಬೆನಿಫಿಟ್ ಅಂತ ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲ. ಅರ್ಜೆಂಟ್ ಯಾಕೋ ಯಾವುದೋ ಹೊತ್ತು ಅಷ್ಟೇ ಅಲ್ಲಿ ನಾವು ಕಂಪ್ಯೂಟರ್ ಹೋಗಿ ಯಾವ್ದು ಬೇಕು SBI ಹೊತ್ತೀಯೋ SBM ಹೊತ್ತೀಯೋ ಹೊತ್ತು. ಆದ್ದರಿಂದ ಅದು ಒಂದು ಏನಿಷ್ಟು ರೂಲ್ ಅದು ಆ್ಯಕ್ಚುಲಿ. ಏನಂದರೆ ನಿಮಗೆ ಸಫಿಷಿಯೆಂಟ್ ಟೈಮ್ ಕೊಡಬೇಕು. ಆಮೇಲೆ ದೇ ಶುಡ್ ಗಿವ್ ವಾಟ್ ಆಲ್ ದ ಬೆನಿಫಿಟ್ಸ್ ಅವೈಲಬಲ್ ಇನ್ ದಿ ದಟ್ ಬ್ಯಾಂಕ್. ಅದು ಯಾವುದೂ ಮಾಡಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ನಾವೇನು ಮಾಡ್ತಾಯಿದ್ದೀವಿ, ಈಗ ಒಂದು ಆಲ್ರೆಡಿ ಇನ್ನೊಂದು ಆಪ್ಷನ್ ಕೊಡಬೇಕು ಅಂತ ನಾವು ಆಲ್ರೆಡಿ ಫೈಲ್ ದಿ ಸೂಟ್. ಆಮೇಲೆ ಇನ್ನೊಂದು ಎರಡನೇದು ಏನು ಅಂತಂದರೆ, ಈಗ ಈ 40-50% ಆಗಿರೋದ್ರಿಂದ ಈಗ ಥರ್ಡ್ ಬೆನಿಫಿಟ್ ನಮಗೂ ಕೊಡಿ ಅಂತ. ಈಗ ಅಟ್ಲೀಸ್ಟ್ ಈ ಥರ್ಡ್ ಬೆನಿಫಿಟ್ ಯಾರಿಗೆ ಅಂತಂದರೆ, ಫಸ್ಟು ನಾವು ಅಂದರೆ ಯಾರು ಮರ್ಜ್ ಆದರೆ ಅವ್ರಿಗೆ ಡಿಮ್ಯಾಂಡ್ ಮಾಡೋದು. ಅಲ್ಲಿ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಆಗುತ್ತಲ್ಲ. ಈಗ ಮರ್ಜ್ ಆದಾಗ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಪೆನ್ಷನರ್ಸ್ ಅಸೋಸಿಯೇಟ್ ಬ್ಯಾಂಕ್ ಪೆನ್ಷನ್ಸ್ಗೆ ಇದರಿಂದ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್. ಫಸ್ಟ್ ಸ್ಟೆಪ್ಪಲ್ಲಿ ಅವ್ರಿಗೆ ಇದನ್ನು ನಾವು ಮಾಡಬೇಕು ಅಂತ ನಮ್ಮ ಜನರಲ್ ಸೆಕ್ರೆಟರಿ ಎಲ್ಲ ರೆಡಿ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಹೇಳ್ತಾರೆ ಇನ್ ಡೀಟೇಲ್. ನಾನು ಇನ್ನು ಬ್ರೀಫ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಇನ್ ಡೀಟೇಲ್ ವಿಲ್ ಟೆಲ್ ವಾಟ್ ಆರ್ ಅನಾಮಲೀಸ್ ಏನಿದೆ, ನಾವು ಏನು ಮಾಡಬೇಕು, ಏನು ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಅನುಕೂಲ ಆಗುತ್ತೆ, ಅದು ಲಾನಲ್ಲಿ ಪರ್ಮಿಷನ್ ಇದೆಯಾ, ಮಾಡ್ಬೋದಾ ಅನ್ನೋ ಎಲ್ಲ ಪ್ರತಿಯೊಂದು ವಿಷಯನೂ ಇನ್ ಡೀಟೇಲ್ ವಿಲ್ ಟೆಲ್. ಸೊ ದಿಸ್ ಮೇಜರ್ ಇವೆರಡು ಏನಂತಾನೆ ಇನ್ನೊಂದು ಆಪ್ಷನ್ ಕೊಟ್ಟರೆ. ಇನ್ನೊಂದೇನೆ ನಾವು ರೆಗ್ಯುಲೇಷನ್ 37 ಅಂತ ಹಾಕಿದ್ದೀವಿ. ಅದು ಎಲ್ರಿಗೂ, ನಾಟ್ ಓನ್ಲಿ ಫಾರ್ ಆಫ್ಟರ್ ಮರ್ಜರ್, ಬಿಫೋರ್ ಮರ್ಜರ್ ಆಲ್ಸೋ. ಈಗ ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟಲ್ಲೆಲ್ಲ ಆಗಿತ್ತು. ಸೊ ನಾವು ಹೈಕೋರ್ಟಲ್ಲಿ, ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟಲ್ಲಿ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ಗೆ ಹಾಕಿತ್ತು. ಈಗ ಅವರು ಡೀಟೇಲ್ ಇದ್ದು ನಮ್ಮ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾದವರು ನಾವು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಏನಂದರೆ ವಿ ಆರ್ ಪೇಯಿಂಗ್ DA ಆಸ್ ಪರ್ ರೆಗ್ಯುಲೇಷನ್ 37 ಓನ್ಲಿ ಅಂತ ರೇಟಿಂಗಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಪಾಪ ರೆಗ್ಯುಲೇಷನ್ 37 ಏನು ರೂಲ್ಸು ಏನು ಅಂತ ಪಾಪ ಯಾರೋ ಹೇಳಿದ್ದಾರೆ, ಸೈನ್ ಹಾಕಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈಗ ಅದನ್ನು ನಾವು ಇದನ್ನು ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ಗೆ ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟಲ್ಲಿ ಆಗ್ತಾ ಇದ್ದೀವಿ. ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಏನೇನು ಕೊಟ್ಟಿದ್ದೀರಾ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಪ್ರಕಾರ ಹೇಳಿ ಡೀಟೇಲ್ ಆಗಿ ಕೊಡಿ ಅಂತ ಅವ್ರಿಗೆಲ್ಲ ಬ್ಯಾಂಕ್ಗಳಿಗೆ ಹೇಳಿತ್ತು. ನಾಟ್ ಓನ್ಲಿ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ, ಇದು ಆಲ್ ಇಂಡಿಯಾ ರಿಟೈರ್ಡ್ ಬ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯೀಸ್ ಅಸೋಸಿಯೇಷನ್ ಅಂತ ಅವ್ರು ಕೇಸ್ ಹಾಕಿದ್ದು. ಯಾರು ಅಂದರೆ ಮೇಜರು ನಮ್ಮ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಬಿಕನೇರ್ ಆ್ಯಂಡ್ ಜೈಪುರ್ SBBJN ಅವ್ರು ಹಾಕಿದ್ರು. ಅದರಲ್ಲಿ ಎಲ್ಲ ಬ್ಯಾಂಕು ಇದೆ, ಆಲ್ ಬ್ಯಾಂಕ್ಸ್, ಎಲ್ಲ ಬ್ಯಾಂಕ್ಗೂ ನಾವು ನೋಟಿಸ್ ಕಳಿಸಿದ್ದೇವೆ ಇಲ್ಲಿಂದನೇ. ಆ್ಯಕ್ಚುಲಿ ಅವರು ಹಾಕಿದ್ರು ನಾವು ಇಲ್ಲಿ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ತಾ ಇರೋದು ಫುಲ್. ಅದೇನಿದೆ ಅದು ಫುಲ್ ಕೇಸೆಲ್ಲೂ ನಾವು ಇಲ್ಲಿ SBM PC ಹ್ಯಾಂಡಲ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಅದ್ರದ್ದು ಖರ್ಚುಗಳು ಎಲ್ಲ ನಾವೇ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಈ ಎಲ್ಲ ಬ್ಯಾಂಕ್ನವ್ರನ್ನ ಕೆಲವು ಬ್ಯಾಂಕ್ನವ್ರೆಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಕೆಲವು ಬ್ಯಾಂಕ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಈಗ ಅದನ್ನು ಇಂಪ್ಲಿಮೇಷನ್ ನಾವೀಗ ವಿ ಆರ್ ಕಾನ್ಸಂಟ್ರೇಟಿಂಗ್ ಆನ್ ಅವರ್ಸ್ ಅಸೋಸಿಯೇಟ್ ಬ್ಯಾಂಕ್ಸು ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ. ಈಗ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ರೇಟಿಂಗಲ್ಲೇ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ಗೆ ಆಗ್ತೀವಿ. ಅದೇ ನಾನು ಆದರೆ ಆ್ಯಕ್ಚುಲಿ ಈಗ ನಿಮಗೆಲ್ಲ ನಾನು ಏನು ಪೆನ್ಷನ್ ಬರ್ತಾ ಅಲ್ಲ, ಇದು ಬರ್ತಾ ಇತ್ತಲ್ಲ ಸ್ಯಾಲ್ರಿ, ಅಷ್ಟು ಪೆನ್ಷನ್ ಬರುತ್ತೆ ಆಸ್ ಪರ್ ರೆಗ್ಯುಲೇಷನ್ 37. ಸೊ ಅದರಿಂದ ಈ ನಾವು ಹೋರಾಟ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಯಾಕಂದರೆ ನೀವು ಯಾವಾಗ ನಮ್ಮ ಪೆನ್ಷನ್ ಆಫೀಸ್ಗೆ ಬನ್ನಿ, ಅವ್ರು ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ಲಿ ಕೇಸ್ ವಿಷಯನ ಇನ್ನೇನಿಲ್ಲ. ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಇನ್ನು ಬೆಳಗ್ಗೆ ಇದ್ದರೆ ಅದೇ, ಬೆಳಗ್ಗೆ ಸಾಯಂಕಾಲ ತನಕ ಅದನ್ನೇ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ಇನ್ನು ಇದ್ರದ್ದು ಏನೋ ಆಫೀಸ್ದೆಲ್ಲ ನಾವು ನೋಡ್ಕೊತೀವಿ. ಆಫೀಸ್ದು ಏನಿದ್ರೆ ಅವರು ಒಂಥರ ನಮ್ಮ ತುಳಸಿ ಪ್ರಸಾದ್ ಇದ್ದಾರೆ, ಕ್ರಿಟಿಕಲ್ ಇದ್ದರೆ ಅವ್ರು ಡಾಕ್ಟ್ರಿಗೆ ಹೇಳ್ರಪ್ಪ ಅಂತಾರೆ. ಸೊ ಹಂಗೆ ಅವರು ಡಾಕ್ಟ್ರು ನಮ್ಮಲ್ಲಿ ಕ್ರಿಟಿಕಲ್ ಇರೋದು ಅವರಿಗೆ. ಇನ್ನು ಬಾಕಿದೆಲ್ಲನೂ ಇಲ್ಲಿ ನಮ್ಮ ಇದರಲ್ಲೇ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ. ಅದರಿಂದ ಈಗ ನಾವು ಎರಡು ಇದಕ್ಕೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಈಗ ಆಮೇಲೆ ಕೋರ್ಟ್ಗೆ ಹೋರಾಟ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ನಿಮಗೆಲ್ಲ ಗೊತ್ತಿದೆ ಕೋರ್ಟ್ ಕೇಸ್ ಎಷ್ಟು ಖರ್ಚಾಗುತ್ತೆ ಅಂತ. ಯಾಕೆಂದರೆ ಈಗ ಆರ್ಡಿನರಿ ಅಡ್ವೊಕೇಟ್ಗೆ 1 ಲಕ್ಷ ಕೊಡಬೇಕು, ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಗೆ 2.5 ಲಕ್ಷದಿಂದ 3 ಲಕ್ಷ ಪರ್ ಅಪಿಯರೆನ್ಸು. ಅವತ್ತು ಲಿಸ್ಟಿಂಗ್ ಆಗಿರ್ತದೆ, ಬರ್ತಾರೆ, ಮುಖ ತೋರಿಸ್ತಾರೆ, ಡೇಟ್ ಮುಂದಕ್ಕೆ ಹೋದ್ರೂ 3 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ನೀವು ಅವ್ರಿಗೆ, ಅಂದರೆ ಪರ್ ಅಪಿಯರೆನ್ಸ್ ಅಂತ. ಅದೇ ಕ್ಯಾಶ್ ಕೊಟ್ಟರೆ 2.5 ಲಕ್ಷ ಇರ್ತದಲ್ಲ, ಕ್ಯಾಶ್ ಕೊಟ್ಟರೆ 2 ಲಕ್ಷ ಕೊಡಿ ಅಂತಾರೆ, ಚೆಕ್ ಕೊಟ್ಟರೆ 2.5 ಲಕ್ಷ ಕೊಡಿ. ನಮ್ಮ ಹತ್ರ ಟ್ಯಾಕ್ಸ್ ನಮ್ಮ ಹತ್ರನೇ ವಸೂಲು ಮಾಡ್ತಾರೆ. ಸೊ ದಿಸ್ ಇಸ್ ದಿ ಏನು ಕೋರ್ಟಲ್ಲಿ, ಹೈಕೋರ್ಟು ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟಲ್ಲಿದೆ. ಆದ್ದರಿಂದ ಸೊ ದಯವಿಟ್ಟು ಯಾರು ನಮ್ಮ ಲೀಗಲ್ ಇದಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ ದಯವಿಟ್ಟು ಕಾಂಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿ. ಆಮೇಲೆ ಯಾರು ಮೆಂಬರ್ ಆಗಿಲ್ಲ ದಯವಿಟ್ಟು ಮೆಂಬರ್ ಆಗಿ ನಮ್ಮ ಕೈಯನ್ನು ಬಲಪಡಿಸಿ. ನಾವು ನಮ್ಮ ಆಫೀಸಲ್ಲಿ ನಿಮಗೆ ಗೊತ್ತಿದೆ 11 ಗಂಟೆಯಿಂದ 5 ಗಂಟೆವರೆಗೂ ನಾವು ಇರ್ತೀವಿ. ಫ್ರಮ್ ಮಂಡೇ ಟು ಫ್ರೈಡೇ 4-5 ಜನ ಅಂತ ಖಂಡಿತ ಇರ್ತೀವಿ. ಅವರು ಸ್ಯಾಟರ್ಡೇನೂ ಬರ್ತಾರೆ, ಪ್ರಸಾದು ಹಾಲಿಡೇಸ್ ಇದ್ರೂ ಬರ್ತಾರೆ, ಕೆಲಸ ಮಾಡ್ತಾರೆ. ನಾವು ವರ್ಕಿಂಗ್ ಡೇ ಹೋಗಿ ಕೆಲಸ ಮಾಡ್ತೀವಿ. ಅದರಿಂದ ದಯವಿಟ್ಟು ಬಂದು ನೋಡಿ ನಾವೇನು ಕಾರ್ಯಕ್ರಮ ಮಾಡ್ತಾಯಿದ್ದೀವಿ, ಏನಾಗ್ತಾಯಿದೆ ಅಂತ ನೋಡಿಬಿಟ್ಟು ದಯವಿಟ್ಟು ನಮಗೆ ಸಹಾಯ ಮಾಡಿ ಅಂತ ಹೇಳಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತೀನಿ. ಥ್ಯಾಂಕ್ ಯು.
Yes, we will start now. Yesterday evening, I was seeing Santoor advertisement. A beautiful young lady appears. Then there is a young boy who feels that she is the right choice and goes there and says, he says beautiful words. In the meantime, a girl will come and call her mummy. Then this gentleman will realize what is the fact. Same thing has happened to most of us when merger took place. All of us were of the opinion that there is nothing like State Bank of India. Natural, no? All State Bank of India, beautiful buildings, excellent interiors, beautiful people, beautiful machinery, technology, everything is number one. But situation is different. I met one of the trade union leader after merger, who is principal office bearer of that association. He said, see, now your bank is merged with State Bank of India. Why don't you merge your association with State Bank of India? I told him, for me, State Bank of Mysore is my maternal home. State Bank of Mysore is my maternal home. Nanna tavaru mane. State Bank of India is my in-laws place. I am always an outsider in my in-laws place. That is what I told him. No, you should not compare all these things. I said, if my father-in-law also treat me like his daughter, perhaps I may also think this also as my family. But my words are true. They never treat, they don't treat. Certainly they are opposed to us. First, when I have a problem, what I do, if treatment is given. Now today, first we shall list all our problems. What are the issues we need to take up? Then what are the actions we have taken? One by one, the actions taken by us, I will explain. Then what you need to do, that also we will discuss. That is our plan of action today. What are the problems? First is superannuation benefit. I mean, in the sense, superannuation benefit, more particularly PF, pension, I mean, which pension, which superannuation benefit is one issue. There are other issues also. Take example, I will take 2-3 examples I will give. First example, in State Bank of India Superannuation Benefit, service is counted from the date of confirmation. But in State Bank of Mysore Pension Regulation, from the date of initial appointment. So even if you have served for 30 years, your service is considered as 29 years, 6 months only. If you have served for 20 years, you will not get pension. This is one problem. Another problem is commutation. How many of you have opted for SBI benefit? How many of you? Most of you. Most of you, if I am right. Okay. Now, of those who have opted for SBI benefit, most of you would not have taken commutation. Am I right? Because SBI people told you not to opt for commutation and you have not opted for commutation. Factor you have not taken into account is that your pension is going to come down. Thereby you are saving tax on your pension. You need to calculate your rate deliberately. I am showing all these documents because it is my experience, personal experience, that some of our own people say that we have not filed the case at all. Okay, so therefore, let nobody have any doubt. I will display all the information, all the documents. Okay, all the information and all the documents I will display, but we will not give case number. But for that, we will give all the information to you. You can check up, you can see that. Okay. ಇಲ್ಲಿಂದ ಲೈಟ್ ಆಫ್ ಮಾಡಿದ್ರೆ ಸಾಕು. I think you can see there, petitioner, okay, petitioners therefore pray that the respondent bank may kindly be directed to extend, extend benefits under regulation 29(5) of Pension Regulation 1995, okay, oh sorry, this is regarding another issue, wait. Yes. Grounds we have made out, I have already told. Therefore, petitioners therefore pray that writ petition may kindly be allowed. The respondent bank may kindly be directed to extend another opportunity to choose one among the 3 terminal benefits in order to enable the employees
to modify their earlier option and to take proper considerate decision. Next, respondent bank may kindly be directed to provide all the details about respective terminal benefit so as to enable the employees to modify their earlier option by making an informed decision. Now, we have sent a letter from All India Retired Bank Employees Association. In another 10-15 days, we will be filing one case only seeking another option. Only seeking another option. But what prayer we are including is, when you extend an option, please give examples of calculation. How much of pension I should get if I opt for SBM pension? What pension I would get if I opt for State Bank of India pension? Understand? So we are asking for specific examples. Specific examples. Why? Then only you will understand what is the pension you should get. You will not be able to calculate because you are not aware. Bank is misleading. Bank is misleading. How they have misled? When this circular was introduced, March 2017, circular was issued. Circular was issued in 2017, 29th March. What was the statement there? Either you opt for this option, this or that. The problem here is, I am reading B. AB's terminal benefits means benefits such as pension, Provident fund, gratuity or any other benefit to which AB's employees are entitled to on cessation of service in accordance with rules, regulations, scheme, circulars, administrative instructions or guidelines governing such benefits in the respective AB. This portion is illegal to the extent that they cannot add scheme, circulars, administrative instructions or guidelines governing such benefits in respective AB. This was the same ground upon which 5-year benefit to those who retired under voluntary retirement scheme was denied. We have won the case. Okay. I will show that portion also. Nobody should have any doubt regarding whatever we are claiming. ಮುನ್ನೂರು ಕೇಳಿವಿ. ಒಂದು ನಿಮಿಷ, ನಾನು ಸುಮ್ಮನೆ ಹರಿಕತೆ ಆಗಬಾರ್ದು. ಆ ದೃಷ್ಟಿಯಿಂದ ಇವೆಲ್ಲವನ್ನೂ ಓದಿ ನಿಮಗೆ ತಿಳಿಯೋ ಥರ ಮಾಡಿಕೊಡ್ಬೇಕು ಅನ್ನೋದೇ ನಮ್ಮ ಉದ್ದೇಶ. ನೋಡಿ, ವಿತೌಟ್ ರೆಫರೆನ್ಸ್ ಟು P. Sadagopan, a larger bench came to the same conclusion in K. Kuppaswamy versus State of Tamil Nadu, wherein spoke thus: statutory rules cannot be overridden by executive orders or executive practice. Merely because government had taken a decision to amend the rules does not mean that the rules stood obliterated. Till the rule is amended, the rule applies. I repeat, till the rule is amended, rule applies. ಮತ್ತೆ ಹೇಳ್ತಾ ಇದೀನಿ, till the rule is amended, rule applies. Even today, amendment has not been effected. As and when it is affected, ordinarily it would be prospective in nature unless expressly or by necessary implication found to be retrospective. It would be opposite to mention here that State Bank of Mysore has not amended its pension regulation. Other judgments quoted in our judgment, and same thing is also quoted in Supreme Court case, our case where we have won. Since the process is not okay. In P. Sadagopan versus Food Corporation of India, it has been reiterated that executive instructions cannot be issued in derogation of the statutory regulation. In a similar situation, in Dr. Rajendra Singh versus State of Punjab, their lordship have reiterated that settled position of law is that no government order, notification or circular can be a substitute of the statutory rules framed with the authority of the law. Accordingly, we are of the opinion that it is impermissible for any party to ignore pension regulation 1995 and create a competing regime to it. The statutory regulation should have been amended before VRS 2000 was implemented for two reasons. Okay. Understood? What they have stated in the circular when they gave offer, it is illegal. What is the meaning of that? What is the meaning of that? If they if they don't implement, if they try to amend our pension regulation through circular instruction, means they have stepped into the shoes of legislature. ಅಂದರೆ ಯಾರು ಕಾನೂನು ಮಾಡೋದು? ಅಸೆಂಬ್ಲಿ ಅಥವಾ ಪಾರ್ಲಿಮೆಂಟ್. ಅಂದರೆ ಇವರು ನಮ್ಮ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಸು ಎಂಪಿಗಳಾಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, MLA ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ದಿ ಅಥಾರಿಟಿ ವಾಟ್ ಈಸ್ ಲೆಫ್ಟ್ ವಿತ್ ಪಾರ್ಲಿಮೆಂಟ್ ಆರ್ ಅಸೆಂಬ್ಲಿ ಈಸ್ ಅಬ್ಸರ್ವ್ಡ್ ಬೈ ಎಕ್ಸಿಕ್ಯೂಟಿವ್. ಇಟ್ ಈಸ್ ಇಲ್ಲೀಗಲ್. This aspect we have also brought to the notice of the bank and also to the court. When we file, we will bring in all these elements and we seek another pension option. Whatever I have read, it has got huge implication on our claims. Huge implication on our claims. Okay. I am speaking so much about law. So much about law. But please understand, merely having law on our side is not enough. Lot more is required. Lot more is certainly required. Okay. I have extracted from Mankutimana Kagga. Okay. I will not read Kannada because I will say, while in the yearning for the unattained, forget not of the attained. Observe the presence of goodness amidst evils. Reminding thee thyself of the privilege thou possess. Let go of that you don't. That is the way to happiness. ನಿಮಗೆ ಈಗ ಇರ್ತಕ್ಕಂಥ ಸವಲತ್ತುಗಳನ್ನ ಮರೆತು ಬಾರದೇ ಇರತಕ್ಕಂಥ ಸವಲತ್ತುಗಳಿಗೆ ಕಣ್ಣು ಹಾಕೋದು ಬೇಡ. ಸಂಟೂರ್ ಅರಿತವರು ನೀ ಏನನ್ನು ಅಥವಾ ಎಷ್ಟು ಗೆದ್ದೆ ಎಂದು ಕೇಳುವುದಿಲ್ಲ, ನೀ ಎಷ್ಟು ಹೋರಾಡಿದೆ ಎಂದೋ ಅಥವಾ ನೀ ಎಷ್ಟು ಭಾರವನ್ನು ಹೊತ್ತೆ ಎಂಬುದನ್ನು ನೋಡುತ್ತಾರೆ. ಏಕೆಂದರೆ ಬದುಕಿನ ಹೋರಾಟದಲ್ಲಿ ನಾವೆಷ್ಟು ಧೈರ್ಯದಿಂದ ತಾಳ್ಮೆಯಿಂದ ಹೋರಾಡಿದ್ದೇವೆ ಎನ್ನುವುದು ಗಣನೆಗೆ ಬರುವುದು. ನಾವು ಪಡೆದ ಜಯಕ್ಕೆ ಅಲ್ಲ. ಈ ಜಗತ್ತಿನ ಹೋರಾಟ ಒಂದು ಪ್ರತಿನಿತ್ಯದ ಗರಡಿ ಮಣಿಯಂತೆ. ಪ್ರತಿನಿತ್ಯ ವ್ಯಾಯಾಮ ಮಾಡಬೇಕು, ಪ್ರತಿನಿತ್ಯವೂ ಕುಸ್ತಿ ಮಾಡಬೇಕು. ಇಲ್ಲಿ ಎಷ್ಟು ಕಸರತ್ತು ಮಾಡಿದ್ದೇವೆ ಎನ್ನುವುದು ಮುಖ್ಯವಾಗುತ್ತದೆ ಹೊರತು ಗೆಲುವಲ್ಲ ಎನ್ನುತ್ತಾರೆ ಮಾನ್ಯ ಗುಂಡಪ್ಪನವರು. when I started searching, I got continuous verses which are most relevant to today's topic. ನೀನು ಗರಡಿಯ ಸಾಮಾನು ಮಾಡಿ ಕುಸ್ತಿಯಲ್ಲಿ ಎದುರಾಳಿಯ ಮೇಲೆ ಗೆಲ್ಲದಿದ್ದರೆ ಏನಂತೆ? ನಿನ್ನ ದೇಹವಂತೂ ಗಟ್ಟಿಯಾಗುವುದಿಲ್ಲವೇ? ಪೂಜೆ ಮಾಡಿದ ಕೂಡಲೇ ಹೊರಸಿಗದಿದ್ದರೆ ಪೂಜೆಯನ್ನು ವ್ಯರ್ಥವೆನ್ನುತ್ತೀಯೇನು? ಗರಡಿ ಸಾಮಿಂದ ದೇಹ ಗಟ್ಟಿಯಾಗುವುದು ಹೇಗೆ? ಸಂದ ಫಲವೋ ಹಾಗೆ ಮುನ್ಸು ಶುದ್ಧವಾಗುವುದೇ? ಪೂಜೆಯಿಂದ ಸಲ್ಲುವ ಉತ್ತಮ ಫಲವೆಂದು ಜಗತ್ತಿನ ಬದುಕಿನಲ್ಲಿ ನಮ್ಮೆಲ್ಲರ ಹೋರಾಟದ ಫಲಶ್ರುತಿಯ ರೂಪವನ್ನು ನಮಗೆ ತೋರಿದ್ದಾರೆ ಮಾನ್ಯ ಗುಂಡಪ್ಪನವರು. ಸಕಾಲಕ್ಕೆ ಬಿತ್ತುವ ಬೀಜ ಮತ್ತು ಬರುವ ಮಳೆಯಿಂದಾಗಿ ಬೆಳೆ ಬರಬೇಕು. ಸಕಾಲಕ್ಕೆ ಸರಿಯಾದ ಬೀಜವನ್ನು ಬಿತ್ತುವುದು ನಮ್ಮ ಯತ್ನ. ಸಕಾಲಕ್ಕೆ ಸರಿಯಾದ ಹದದಲ್ಲಿ ಬರುವ ಮಳೆ ದೈವ ಕೃಪೆಯಿಂದ ಆಗಬೇಕು. ನಮ್ಮ ಪ್ರಯತ್ನ ಮತ್ತು ದೈವ ಕೃಪೆಗಳು ಸೇರಿದರೆ ಬೆಲೆ ಹಲುಸಾಗಿ ಬೆಳೆಯುತ್ತದೆ. ನಮ್ಮ ಪ್ರಯತ್ನವನ್ನು ಮಾಡದಿದ್ದರೆ ಅದು ನಮ್ಮ ಕರ್ತವ್ಯ ಲೋಪ. ದೈವ ಕೃಪೆಯಾಗದಿದ್ದರೆ ದೈವ ಮುನಿಸಿಕೊಂಡಿದೆ ಎಂದು ತಿಳಿಯಬೇಕು. ಹಾಗಾಗಿ ನಮಗೆ ನಮ್ಮ ಕೆಲಸ ಕಾರ್ಯಗಳಿಗೆ ಸೂಕ್ತ ಫಲ ಸಿಗುವುದೋ ಇಲ್ಲವೋ ಎಂಬ ಅರಿವಿಲ್ಲ ಎಂಬ ಉಲ್ಲೇಖ ಮಾಡಿದ್ದಾರೆ ಮಾನ್ಯ ಗುಂಡಪ್ಪನವರು ಈ ಮುಕ್ತದಲ್ಲಿ. Each of this verse is relevant to us. Why? Because now we are fighting. Now we are fighting whom? We are fighting State Bank of India. When we filed contempt petition, do you know who appeared for State Bank of India? Shri Tushar Mehta. Shri Tushar Mehta appeared for State Bank of India. But we did not fail. We have also fielded an appropriate senior advocate. Present Attorney General Shri Venkatramani was our advocate. Why I am saying this is, we need lot of homework to do and lot of money needs to be spent. 3 examples. Single judge bench of that ABOA case filed in 2017, we have got orders in 2025. We filed case in 2002, we got order in 2018. Still we are fighting. Then Singla's case was filed in 2006, still case is pending before Supreme Court. Like that, court cases we do not have control. Results we do not have control. We have got only control over information provided, fielding good advocate and assisting with them with full information. That we will do it. That certainly, I am proud to say that other than State Bank of Mysore, there is no other retiree organization which he said, talk to Prasad, he will help you. Okay? So, this kind of an impression we have created in the industry. When we say it is the ultimate, to that extent we have established our credentials. What? Okay. Now, why this court case? Why another option? Which option you should choose? Why we are seeking option? If they give you pension in terms of pension regulation, okay? What is the difference? In case if we get SBM benefit, what would be the difference? 35. Difference is 46,171. Basic pension 9,273. Difference is 26,954. Basic pension 13,085. Difference is 27,499. That is up to those who have retired under VRS and retired up to 31/10/2017. Now those who retired between 2017 and 2022, 31st October. Various basic pension. I will give some examples. 41,220. Difference 67,201. 58,060. Difference is 96,518. 96,518 means what is pension? 1,86,360. Okay. Then 48,440. Pension is 158. Difference is 83,750. 12th by part 8. I will take 63,360 because figure looks fancy. If basic pension is 63,360 rupees, 1,26,720 is the difference. Pension is 2 lakhs. Pension is 2 lakhs. 1 minute. ನಿನ್ಗೋಸ್ಕರ ಕಾಯ್ತಾ ಇದ್ದೀನಪ್ಪ. ನೀನು ಬಾ ವೇಟಿಂಗ್ ಫಾರ್ ಯು. ಓಕೆ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಓಕೆ ವೈ ದಿಸ್? ವೈ ಐ ಆಮ್ ಶೋಯಿಂಗ್ ದಿಸ್? How we should get it. I will show you another document now, which SBI reply ಎಲ್ಲ ನಾನು ಮಾಡಿದ್ದೆ. ನೀವು ನನಗೆ ಹಲೋ ಹೇಳಿ ಸರ್. ಹಲೋ ರೇಡಿಯೋ ಕೊಡ್ಲಾ? ಓಕೆ. ಹಾಂ ಹಾಂ, ಕನ್ನಡ. ಓಕೆ ಓಕೆ. ಹ್ಞೂ. ಹಾಕಿದ್ದೀನಿ, ಅದೆಲ್ಲೂ ಸಿಗಲಿಲ್ಲ. ಹಂಗೆ ಅದು ತಕ್ಷಣಕ್ಕೆ ಸಿಗಲ್ಲ. ಹೆಸರು ಕೊಟ್ಟಾಗ ನಾನು ಏನೋ ಬೇರೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಇದೆ, ಓಕೆ, ಇದರಲ್ಲೇ ಇದೆ ನೋಡಿ. ಓಕೆ, ಇದರಲ್ಲಿ ಇದೆ ಅದು. ಓಕೆ, ತೋರಿಸ್ತೀನಿ ಬಿಡಿ. ಇದು ದಿಸ್ ಈಸ್ ದಿ ರಿಪ್ಲೈ ವಿ ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ಫ್ರಮ್ State Bank of India advocate. State Bank of India advocate has given this reply. In the reply regarding why I was showing so much of figures, ಯಾಕೆ ನಿಮಗೆ ಅಷ್ಟೊಂದು ಪೆನ್ಷನ್ ಅಷ್ಟೊಂದು ದುಡ್ಡು ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ ಅಂದರೆ, ನಮ್ಮ ಕ್ಲೈಮು ಪೆನ್ಷನ್ ರೆಗ್ಯುಲೇಷನ್ ಪ್ರಕಾರ ಪೆನ್ಷನ್ ಕೊಡಬೇಕು ಅನ್ನೋದು, ಪೆನ್ಷನ್ ರೆಗ್ಯುಲೇಷನ್ ಪ್ರಕಾರ ಪೆನ್ಷನನ್ನು ಕೊಡಬೇಕು ಅನ್ನೋದು. This reply, when we sent contempt notice, this is the reply given by State Bank of India advocate. RPK advocates and consultants, the reply is given by them. What they have stated: dearness relief has been computed in accordance with Regulation 37 of the Bank Employees Pension Regulation 1995. What are we asking? What are we asking? We are also asking for payment of pension in terms of regulation, more particularly Regulation 37 in respect of payment of dearness allowance, dearness relief. What bank has said? What bank has said? They have already paid. They have already paid. Now what we should do? We should tell the court, give the pension regulation and one example and show the court that bank is not paying. Now our responsibility is only to show the court that bank is not paying in terms of their own statement. It is not any imagination. It is not our claim. This is what they have returned. They have given. This is the letter from them. ಬ್ಯಾಂಕಿನ ವಕೀಲರು ನಮ್ಮ ಕಂಟೆಂಪ್ಟ್ ನೋಟಿಸ್ಗೆ ಉತ್ತರವನ್ನು ಕೊಡಬೇಕಾದ್ರೆ ಹೇಳಿದ್ದಾರೆ, ಪೆನ್ಷನ್ ರೆಗ್ಯುಲೇಷನ್ 37ರ ಪ್ರಕಾರ ನಾವು ಪೆನ್ಷನ್ ಅನ್ನು ಕೊಟ್ಬಿಟ್ಟಿದ್ದೇವೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಹ್ಯಾಸ್ ಬೀನ್ ಪೇಯ್ಡ್, ಕೊಟ್ಬಿಟ್ಟಿದ್ದೇವೆ ಅಂತ. ಅವರು ಕೊಟ್ಟಿಲ್ಲ, ಕೊಡ್ತಾ ಇಲ್ಲ. ನಾವು ಕೋರ್ಟ್ಗೆ ಮನವರಿಕೆ ಮಾಡಬೇಕಾಗಿರೋದು ಏನಂದ್ರೆ, ಪೆನ್ಷನನ್ನು ಅವರು ಹೇಳಿರುವಂತೆ ನಮಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ. ನಾನು ಪೆನ್ಷನ್ ಸ್ಲಿಪ್ ಕೊಡಬೇಕು, ರೆಗ್ಯುಲೇಷನ್ ಅನ್ನು ಕೊಡಬೇಕು. ಇವೆರಡರ ಪ್ರಕಾರ ಏನು ಬರುತ್ತೆ ಅನ್ನೋದನ್ನು ಅವರಿಗೆ ಕೋರ್ಟಲ್ಲಿ ತೋರಿಸ್ಬೇಕಾಗತ್ತೆ. ಮತ್ತೆ ಯಾರು ಕೋರ್ಟ್ ಕೇಸೇ ಹಾಕಿಲ್ಲ, those who are saying we have not filed the court case number is there, and bank advocate certainly will not reply if we have not filed court case referring to case numbers. At least please do not believe if anybody says spread stories that we have not filed case, we are not fighting. They are cheating you. They are cheating you. They are misguiding you. They are misrepresenting. It is a criminal offense. Okay? It's not only this, there is something more. Court ವಿಷಯಕ್ಕೆ ಬಂದಾಗ I will explain. What action we have taken, I will explain. Now, what is your entitlement? I will explain all your entitlements. Then what actions we have taken, I will explain. Everything I will, today, deliberately we wanted to have this because everybody should have information in black and white. Only to that extent, only for this reason, I am exhibiting this.
ಕೇಂದ್ರ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾಪಿಸಿ
ಯಾತಕ್ಕೋಸ್ಕರ ಬರುತ್ತೆ ಅಂದರೆ ನಮ್ಮ ಪೆನ್ಷನ್ ರೆಗ್ಯುಲೇಷನ್, ಅವರ್ ಪೆನ್ಷನ್ ರೆಗ್ಯುಲೇಷನ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಅಮೆಂಡೆಡ್. ಅವರ್ ಪೆನ್ಷನ್ ರೆಗ್ಯುಲೇಷನ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಅಮೆಂಡೆಡ್ ಫ್ರಮ್ 1995. From the first day, State Bank of India has not amended its pension regulation, our pension regulation. Therefore, the formula what is there in our pension regulation is you can see now. This is the gentleman who has retired 2020 May. 2020 May, basic pension 47,470 rupees. DA, what is being paid? This is as per August 23, 632 slabs, 21,001, total pension 68,471. How it should be calculated? As per pension regulation, up to 2,400 at 0.35%, up to 3,850 0.29%, up to 4,100 0.17%, over 4,100 0.09%, total 1,638 rupees. Difference is 79,637. This is the document which is we have already given to court. This calculation has already been given to the court to substantiate our claim. So this case pertains to those who have retired after merger also. Now we have got our trump card. What is this? Idenidu Gazette notification. Gazette notification. What they have stated, provided that in respect of the employees of the banking institution who have opted, subject to their eligibility, the pension regulation of the banking institution, for us it is State Bank of Mysore, those employees shall become members of the fund as per these regulation as may be determined by the central board of the bank, and such members shall be eligible for pension in conformity with the rules, pension regulation of such banking institution by which they were governed. If you are from State Bank of Mysore, you are governed by State Bank of Mysore Employees Pension Regulation 1995. So, if you have opted for State Bank of Mysore pension, you are eligible for pension as provided in State Bank of Mysore Employees Pension Regulations 1995. Understood? ಅರ್ಥ ಆಯ್ತಾ? ನೀವು SBI ಪೆನ್ಷನ್ ಅನ್ನು ತಗೊಂಡಿದ್ದ ಪಕ್ಷದಲ್ಲಿ ಮರ್ಜರ್ ಆಗಿದ ದಿವಸ ನಮ್ಮ ಪೆನ್ಷನ್ ರೆಗ್ಯುಲೇಷನ್ ಏನಿತ್ತೋ ಅದರ ಪ್ರಕಾರ ಪೆನ್ಷನ್ ಅನ್ನು ಕೊಡ್ತೀವಿ ಅಂತ ಅವರು ಅವರ ರೆಗ್ಯುಲೇಷನ್ ಅನ್ನ ಅಮೆಂಡ್ ಮಾಡಿ ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ. Okay. Sure, bank itself has stated. What is that we are asking? ನಾವು ಕೇಳ್ತಾ ಇರೋದೇನು? Is there anything else? No. We are only asking for this. Are we eligible for 2 lakh pension? 2 ಲಕ್ಷ ಪೆನ್ಷನ್ ಬರಲಿಕ್ಕೆ ಅರ್ಹತೆ ಇದೆಯಾ ಇದರ ಪ್ರಕಾರ? ನಾವು ಕಾಕಕ್ಕ ಗುಬ್ಬಕ್ಕ ಕತೆ ಹೇಳಲ್ಲ. ಯಾವುದು ದಾಖಲೆ ಇಲ್ಲದೆ ಯಾವ ಮಾತನ್ನು ಹೇಳಲ್ಲ. ನಾವು ಧೈರ್ಯದಿಂದ ಹೇಳ್ತೇನೆ, ಕಮ್ಯುಟೇಷನ್ 10 ವರ್ಷಕ್ಕೆ 10 ವರ್ಷ 8 ತಿಂಗಳಿಗೆ ಬೇರೆಯವರೆಲ್ಲರೂ ಹೇಳಿದಾಗ ಶತಾಯುನಲ್ಲಿ ಪ್ರಿಂಟ್ ಮಾಡಿದ್ವಿ. ವಿ ಸೆಡ್ ವಿ ವಿಲ್ ನಾಟ್ ಗೆಟ್ ದಟ್, ವಿ ವಿಲ್ ನಾಟ್ ಗೆಟ್ ದಟ್, ವಿ ಕೆನಾಟ್ ವಿನ್. ಇಫ್ ವಿ ಹ್ಯಾಡ್ ಎನಿ ಚಾನ್ಸ್ ವಿ ವುಡ್ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಟ್ ಕೇಸ್ ಲಾಂಗ್ ಟೈಮ್ ಬ್ಯಾಕ್. ವೈ ಇಟ್ ಇಸ್ ನಾಟ್ ಪಾಸಿಬಲ್? Because it is against the pension regulation. Banks have quoted pension regulation to deny us. We are also doing the same thing now to get it. We will get it. Okay? ಧೈರ್ಯವಾಗಿ, if there is only one institution which said in black and white, we will not get it, it is only we. It has to be done only through bipartite settlement, otherwise it is not possible. For your information, I am sharing one more information with you. In 2021, Government of India directed all public sector banks to amend their commutation table, reducing the commutation factor. UFBU has not allowed it. They said, our pension is out of bipartite settlement. Without entering into settlement, you cannot alter my benefit. That is how it is. Still, all the factor is available. In case if they were not to do it, those who retired after 2021 would have got lesser amount of commutation. In IOB, they implemented. After union and association took up the matter, now they are paying as per our existing regulation, but they are obtaining indemnity letter. In case if it is amended from a retrospective effect, we will be recovering money. So, we need to understand full implication of whatever we are doing. Now, understood now? You have any doubt? Okay.
Special allowance has it been taken care of?
I will come to that also. I will come to that also. Okay. I do not want to debate. Okay, let me speak about special allowance. Please understand, I would say proudly that we are the only organization boldly say that you cannot win a case in respect of special allowance. If at all they have to do it, they have to do it through settlement only. Why? Because if your special allowance is counted for pension, then What about those who are in service? Their salary and allowances are determined by bipartite settlement and joint note. Okay, but bipartite and joint note has decided that you will not get pension on this amount. Now you are questioning bipartite settlement. From definition to you have gone to questioning the bipartite settlement. Why you cannot question? I can quote several judgments. No court, unless there is illegality, no court strikes down any portion of bipartite settlement. Any portion of bipartite settlement. Because illon cheriದೆ ಬನ್ನಿ ನಿಂತಿರೋರು ಬನ್ನಿ ಇಲ್ಲಿ ಇದೆ ಚೇರು ಬನ್ನಿ no. Okay, then what would happen to employees? Their salary will come down. The moment they get a pension on special allowance, it is not only pension on special allowance, NPS also should be calculated on that special allowance. Okay, this is the real truth. I am talking about law. On account of your special allowance, whether there is any reduction in pension, like we had 16161684, our pension was reduced. Whether there was any such situation now, no, your pension is not reduced. You are not, your pension, they are not reducing. ನಿಮ್ಮ pension ಕಡಿಮೆ ಆಗ್ತಾ ಇಲ್ಲ ಸ್ಪೆಷಲ್ ಅಲೋವೆನ್ಸ್ ಇಂದ. ಬೈಪಾರ್ಟೇಟ್ ಟು ಬೈಪಾರ್ಟೇಟ್ ನಿಮ್ಮ pension ಜಾಸ್ತಿ ಆಗ್ತಾನೆ ಇದೆ. One. Number two, pension regulation definition says any allowance which carries Provident Fund and DA, it is counted for pension. Special allowance attracts DA, no problem. But Provident Fund is not there on special allowance.
They have deliberately fooled us.
They have not fooled you. They have not fooled you. Please, you are in service. I am maybe harsh. Please excuse me if I am harsh. When we are in service, when we were in service, we are happy. We feel we are fooled only after retirement. We were happy while in service because we were getting higher amount of salary. Okay, you have to sign settlement for increasing the salary, not increasing the pension. This is what employees wanted. Okay, have you ever seen any employee, even now, asking for pension and PF on Provident on special allowance? Existing employee. Who has to sign the settlement? It is UPU who has to sign the settlement. UPU represents employees and officers who are existing. Do they want? They don't want. Will they sign a settlement damaging the interest against the interest of their own employees and get us special PF on special pension on special allowance? Mr. Koteshwar Rao, why are you worried about 2,000, 3,000 rupees pension when I am showing you 1,20,000 rupee increase in pension? ಇರುವುದನ್ನು ಬಿಟ್ಟು ಬಾರದಿರುವುದನ್ನು ನೆನೆದು. Understood? Okay. Okay, so now coming back to next another benefit. Okay. Now how many of you want to continue in SBI? How many of you want to continue with SBI pension? I am sure nobody, correct? Objective of this meeting is that all of you should understand, merely because you get 8 lakhs, 10 lakhs more, don't go in for that. This case will not be decided in next 15 days, 1 month, 2 months. It will take years. Why I am saying it takes years? If it takes years, is it good or bad? Good. You have not understood it is good. It is good. Do you know why? you will get huge amount of money. Perhaps some may even see 1 crore arrears. 1 crore arrears. Correct? Okay. Right. In the light and wine, it is not our intention to delay. Please, okay. Are you happy? Are you happy? ಒಂದು ಚಪ್ಪಾಳೆ ಮಲ್ಕೊಂಡಿದ್ದಾರೆ ಹೇಳಿ. Okay, next. There is lot more information for you. Okay, lot more information for you. Some funny part I am telling you, whom we are facing, how State Bank of India treats us. I will tell you. When, we had filed a case in Supreme Court in the name of All India Retired Bank Employees Association. We are affiliated to All India Retired Bank Employees Association. We had filed a case. The case was dismissed by Delhi High Court. Then All India Retired Bank Employees Association filed civil appeal before Supreme Court. I am also one of the petitioners before Karnataka High Court. We won the case. Sir, ಜಾಗ ಇಲ್ಲದೆ ಇರೋರು ನಿಂತ್ಕೊಳ್ಬೇಕಾಗಿ ಬಂದರೆ ದಯವಿಟ್ಟು ಅಲ್ಲಿ ಮೆಟ್ಲ ಮೇಲೆ ಕೂತ್ಕೋಬೋದು, ಕೂತ್ಕೊಳ್ಳಿ, ನಿಂತ್ಕೊಂಬ ಅಗತ್ಯ ಇಲ್ಲ. ಇಲ್ಲ ಮೇಲೆ ಬಂದರೆ ನಾವು ಚೇರ್ ಇದೆ ಒದಗಿಸ್ತೀವಿ. ಓಕೆ, ಸೊ ವಿ won the case. There are two important items which affects you also, that I was about to tell. There are two issues. First issue is all the benefits that are available in Reserve Bank of India should be extended in our public sector banks. All pension benefit available in Reserve Bank of India should be extended to public sector banks, bank members of respondent banks. That means all of us. We are eligible for Reserve Bank of India benefit. There are 4 benefits which are available in Reserve Bank of India which are not paid in our banks. The 4 benefits. First benefit, full pension for 20 years. Full pension for 20 years. Pension if you have served for 10 years. So all those who took voluntary retirement, serving less than 30 years in SBI, less than 28 years in bank, they will get full pension. Second is last 10 months average pay or last pay drawn, whichever is higher. Third most important benefit is service is reckoned not from the date of permanent employment but from the date of temporary employment, provided there is no break. You do not know, there are many people in our bank who are not even receiving because their temporary service is not included for calculation of pension. 10-year service is not there, therefore they are not getting. They will all get this pension. Fourth benefit is irrespective of length of leave on loss of pay on medical grounds, unless bank says such leave is treated as leave on loss of pay, entire service is counted for pension. There are many women employees who were on leave for 3 years, 4 years. They will all get pension on that period also. These 4 benefits. Then another prayer was, you should make our association a party whenever any settlement, meeting, seminar is conducted and recognize us. Whenever you take any decision for or against us. This is the second prayer. when our civil appeal is allowed. When our civil appeal is allowed, which means all these prayers are allowed. All these prayers are allowed. Unfortunately, Supreme Court has not dealt with any of these issues. Therefore, including State Bank of India, what they say is there is no such order. There is no such order. But they know that they have to pay because they have only got judgment in 100% DA case quoting the law what I am going to refer. Law is simple. You must have heard speaking order, non-speaking order. If somebody is dismissed, ಯಾರೋ ಒಬ್ಬರನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು, ನಿಮ್ಮನ್ನ ನಾಳೆಯಿಂದ ಡಿಸ್ಮಿಸ್ ಮಾಡಲಾಗಿದೆ ಅಂದರೆ ಅದು ನಾನ್ ಸ್ಪೀಕಿಂಗ್ ಆರ್ಡರ್. If you are dismissed with effect from today, if there is one sentence order, it is a non-speaking order. Speaking order means you have to give the reasons. Supreme Court has allowed our civil appeal by a non-speaking order. Non-speaking order is binding on all the respondents. State Bank of Mysore is also a respondent in the court case. Therefore, all of us are eligible for this benefit. When banks did not implement, we filed a contempt petition. Including this DA, we asked in our contempt notice. We filed a contempt petition. Supreme Court decided that in case if your prayers, if whatever you are entitled to it is not paid, either you can give a representation or approach appropriate forum for in case of non-implementation or partial implementation. Andre, I will not again agitate. I should file case only for implementation. Then we filed writ petition before Delhi High Court. Delhi High Court said, give a comprehensive representation and banks shall pass speaking orders within 6 weeks. Detailed speaking order. If there is any surviving grievance, launch appropriate forum for getting it implemented. This is the order of Delhi High Court. If anybody has got doubt about these things, I will exhibit orders also. I have nothing to hide. I have nothing to hide. Okay. Then we sent notices to all the banks. Notices to all the banks. Bank did not reply within 6 weeks. We sent reminder, but we received a letter. Then when we complained to finance minister, we received a letter from the bank addressed to State Bank Retirees Association, stating that your representation should have been directly from All India Retired Bank Employees Association, not from State Bank Retirees Association. What we had done was, we had enclosed this representation of All India Retired Bank Employees Association to covering letter of SBRA. So they said you have not received the representation. But they forgot. We had sent email on 1st of November. Then thereafter, we sent 2 more times representation and directly by registered post also it was sent. Still they did not reply. Evasive replies were there. Then again we complained to finance minister. Thereafter, whatever reply I read, it is in response to that. It is in response to that. This is also after we sent contempt notice. After we sent contempt notice. It is, I will read last 2 paragraphs from the reply from the advocate. They have threatened us with action. No problem, we will see. When this was told to one leader of SBI Pensioners Association, SBI Pensioners Association, he said, ಏನ್ರಿ ಅವರು ಪ್ರಸಾದ್ ನಮ್ಮ ಚೇರ್ಮನ್ಗೆ ಕಂಟೆಂಪ್ಟ್ ಕೇಸ್ ಹಾಕ್ತಾರಂತೆ ಚೇರ್ಮನ್ ಮೇಲೆ. ದಿಸ್ ಇಸ್ ದಿ ರಿಯಾಕ್ಷನ್ ಆಫ್ SBI Pensioners Association leaders. This is the reaction. Unfortunately, many of our members are members of SBI Pensioners Association. They don't know every rupee what you are paying is being used for improvement of their pension, not your pension. They are opposed to it. I will show you the document. Why SBI Pensioners Association opposes? I will show you the document, 2 documents. Whatever I am speaking today, everything I am producing, proof in black and white. This is again reply from the advocate, same advocate. He says,
ಥ್ಯಾಂಕ್ಸ್ ಯಾರು ಹೇಳಿದ್ದೀರಿ?
ಯಾರಿಗೂ ಹೇಳಿಲ್ಲ,
ಇದೊಂದು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಬೇಕು.
ಹೇಳ್ತೀನಿ, ಬರ್ತಾನೆ ಪ್ರಸಾದ್, ಬರ್ತಾನೆ. Samadhan Pakwada. How did they get it? We got Samadhan Pakwada because of our effort. We met Finance Minister. Finance Minister called Chairman of State Bank of India. She clearly instructed the Chairman of State Bank of India to hold meeting with us. They subverted our instruction and introduced Samadhan Pakwada. And she has tweeted, it is not our tweet, our claim, Madam Finance Minister herself has tweeted. I will also show that. I will read this. Further, it was also advised that Samadhan Pakwada is conducted at quarterly intervals wherein the bank's senior official attends the meeting and look into pensioners' concern. And the said meeting is for all pensioners. See the next sentence. You must understand. The Register Association, that is SBI Pensioners Association, in the meeting held with the bank had never raised any objection as being raised by your client. What is the meaning? What is the meaning? Those who have got no for SBI Pensioners Association should answer this question, which means they have no objection if the bank does not pay pension correctly to us. They are happy with that. Not only this, there is one more. Okay, if you want me, I will read from that. SBI, when we demanded CPF, SBI Pensioners Association has written in black and white, demanding third benefit is an attack on SBI pensioners and their federation. But we have got some of us, some of our own members mobilize membership for SBI Pensioners Association. Are we not cheating, deceiving our own self? We are cheating ourselves. When somebody is fighting for your benefit, you are trying to mobilize membership for someone who opposes benefit to you. Forget about claiming. What is this third benefit? Okay. So far, whatever I have said, have you got any doubt?
Sir, contempt petition to present state of
No, contempt, there is no contempt petition now. Disposed of with the direction to, now we are filing, okay, now we are filing this week. Last week was the first week after Delhi High Court reopened. I will explain that later, what action we have taken, then I will explain. Now, let us not deviate, okay. Now, next is another important benefit. Okay, so therefore, this option given is wrong. Rules, regulation alone, scheme, circulars, administrative instructions, guidelines governing such benefits, in AB, this portion is illegal. We are claiming second option, excluding this. If we exclude that, whatever figures I said is applicable to us, including Provident Fund. I'll come to Provident Fund later. Okay, so next benefit is our Provident Fund. Why we are demanding Provident Fund?
ಮಾಡಿ ಸರ್. ಇಲ್ಲ ಇನ್ನು ಅವರಿಂದ ಮುಗಿಸಿಲ್ಲ, ಅದಕ್ಕೆ ಅವ್ರು ಮೀಟ್ಲ ಕಡೆ ತಿರುಗ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ,
ವೋಟ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ಅಂದು ಅದಕ್ಕೆ
ವೋಟ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ಅಲ್ಲ, 400 ಜನ ಬಂದಿದ್ದಾರೆ. ಅಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕಿತ್ತು ಒಂದು ಸ್ವಲ್ಪ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ.
ಅದಕ್ಕೆ ಹೋಗಿದ್ದು.
ಓಕೆ 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 ಓಕೆ
ಹೇಳಾಯ್ತು ಸರ್.
ಹೇಳಿದ್ದೀರಾ? ಓಕೆ. ಓಕೆ, ನೆಕ್ಸ್ಟ್. ದಿಸ್ ಈಸ್ pension. Okay, Provident Fund regulation. In 2019, State Bank of India has amended their Provident Fund rules also. Their Provident Fund rules also. What they have stated, I will read. Provided that in respect of those employees who have opted subject to their eligibility for the Provident Fund benefits of the other bank, Provident Fund regulations of other bank shall govern those employees. If you have opted for State Bank of Mysore Superannuation Benefit, what are the benefits available to you? Pension, Provident Fund, gratuity. Okay. Now we are in Provident Fund. What they say is, your Provident Fund is payable for Provident Fund, as per Provident Fund rules, as existing on the date of merger. Provident Fund is paid as per your Provident Fund regulation, provided you opted for Provident Fund. Those who have joined bank after 26th March 1996, they are all governed by pension as per pension regulation. As per pension regulation. So, as per OSR, they are all eligible for Provident Fund. As per appointment order, they are eligible for Provident Fund. Also, in addition to pension, they are also eligible for Provident Fund also, pension also. Provident Fund as per State Bank of Mysore employees Provident Fund rules. Please remember, like pension regulation, our Provident Fund rules are also not amended. That is also a subordinate legislation. Which means Provident Fund should be paid not in terms of pension regulation. It should be paid in terms of Provident Fund rules. Vaso will watch appointment orders given to an officer, probationary officer, states that you are governed by Officers Service Regulation. Only in 2002 it is amended. So till such time, all the officers are governed by OSR. So they are eligible for Provident Fund. You cannot fix a cut-off date dividing same class of people into two, Nakras case. Okay? So Provident Fund should be paid to all of us. Then what about those who joined the bank before 1996? There are two aspects of law. First one, Kasturi, State Bank of India, Chairman State Bank of India versus Kasturi, and Nakara's case. Both the cases says that you cannot slice retirees into two. They belong to same class. Same class. Based on a cut-off date, you cannot divide. So they cannot divide us. And in Kasturi case, it says, if any benefit is given to anybody after some time, that benefit should also be extended to those who are eligible for it. So we are eligible for Provident Fund, therefore Provident Fund should also be paid. Should also be paid. How did State Bank of India pensioners got this 50%? A committee was formed in 2016 under the chairmanship of Dr. Murmu. Murmu committee said that Provident Fund, 40-50% payment of pension at 40-50% is correct because they are enjoying 10% Provident Fund. They are enjoying 10% Provident Fund. Now, after Madam became finance minister, she is sympathetic to pensioners, okay, and employees, bank employees. What she said, she agreed for extension of 50%. Another committee was formed. This offer is by the State Bank of India, Government of India. It is not through a court order. Government of India in the court said that if they give representation, we will consider representation. Then committee, before the committee, Federation of State Bank of India Pensioners Association also appeared, and unfortunately, general secretaries, two former general secretaries, one existing general secretary of IBOC also went and submitted a representation. Why I am saying this is, IBOC has got membership who are not receiving third benefit also. Okay, ignoring their concern, they said, they submitted a representation stating that there cannot be discrimination. Everybody should get in the same rule. In State Bank of India, Federation has gone further. They have said in government and in other public sector banks, pension is in lieu of contributory Provident Fund. But in State Bank of India, pension is in existence from Imperial Bank days. From 1905 we are enjoying pension. Therefore, pension should be, all those who are receiving pension from State Bank of India should also get pension available in other public sector banks. This is their demand. It is recorded in the report. But false information, it is a wrong information. Till 1972, we had two benefits, they also had two benefits. We had two benefits, Provident Fund and gratuity. They had pension and Provident Fund. It was a contributory pension scheme. Only in 1964 it was converted into non-contributory. There was a ceiling in 1995 when we opted for pension, our pension. The managing director was the deputy managing director of State Bank of India. His pension was less than that of our scale 3 officer. But today what happened? Allowed. Okay. This committee, while deciding, has said that in the same rule of the same bank, there cannot be two different rates. Now, how many rates are there in State Bank of India? They say two rates. There are 4 rates. One, original SBI. Next, State Bank of Saurashtra, State Bank of Indore. Number 3, EAB, 5 EAB employees who have opted for superannuation benefit of SBI. Fourth category, superannuation benefit of associate bank. How can there be 4 rates? We would be, next, we are taking care, on these basis, we will be claiming Provident fund from the date of joining if you are opting for associate bank pension. If you are opting for associate bank pension, when you get an option. We will not leave, we will fight it out. We are confident of success. Okay? Having said that, none of us have got control over 2 things. First, how a judge thinks. How a judge thinks. Number 2, time. I have no control. Perhaps none of us have got control. Except these 2, from our side, whatever needs to be done, we will be doing it. We will be doing it. Okay? What are the actions we have taken? What are the actions we have taken? I was telling about, Ramchandra was asking about contempt petition. See, 2019, Commune conducted a campaign. Requested those who have retired and who are our members, we have requested them to give 5,000 rupees, join the legal struggle, and we have handed over them calculation sheets, approximate arrears till 31st December 2019. Then we collected debit authorizations, 5% in up to 9th bipartite, 2 months pension up to in the 2 months pension in respect of those who retired till then from SBI. Okay. So later, what are the actions we have taken? What are the actions we have taken? We had filed a contempt petition in 2019 by those who were original petitioners in Karnataka High Court, including me. Their dearness allowance was one of the issues. Supreme petitioners are claiming dearness relief in terms of pension regulations. So in case of any grievance of the petitioners, they are directed to approach appropriate forum for enforcement of the order. So taking advantage of that, but for the order, I had no authority to file a case for somebody who has retired in 2005 because 15-year period is over. There is something called as delay and laches. You cannot go after 15 years. For 15 years you felt that the pension what you are receiving is correct. After 15 years you cannot go back and say that no, my pension is wrong. Okay? You have seen 12 ವರ್ಷ ಒಂದು ಮನೆಯಲ್ಲಿದ್ದರೆ adverse possession ಆ ಜಾಗ ನಂದೇ. When that is the case, same law is applicable. Bank will say he was agreed that the pension what he was receiving is correct, so he cannot claim. Took advantage of this order of Supreme Court, and we have filed the case in respect of all remaining. Well, we made our move correctly. What we have done is, we have filed cases in respect of, in 5 other associate banks, this 5-year benefit is not given. In 5 associate banks, they have not given 5-year benefit. What we did, we filed that case. We added this DA, pre-2002 retirees issue also. In Karnataka High Court, when we filed, prayers are original prayers. Where I am also one of the petitioners, 34619, writ petition 34619, same prayers are extracted in Karnataka High Court. Why we did it was because this case is already decided by Supreme Court. So next court cannot alter the decision. No other court has got authority to change the decision except 15 bench judge of Supreme Court. Otherwise, this judgment cannot be reversed. This judgment cannot be reversed because this judgment is based on even 9 judge bench also, decision of 9 judge bench also. So we file the case. There, our prayer is pay dearness relief irrespective of date of their retirement. Respond, you can see here, under the dearness relief, under Regulation 37 Appendix 2, all those who have retired under VRS 2001 and also to all the employees of erstwhile associate banks irrespective of date of their retirement. Case ಹಾಕಿದೀವಾ? ನೀವು ಬೆನಿಫಿಟ್ಟೇ ಬರಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಕೇಸೇ ಹಾಕಿಲ್ಲ ಅಂತ ಮೆಸೇಜ್ ನೋಡಿದ್ದೀನಿ ನಾನು. ಹಾಕಿದೀವಾ? Merely because we have not given the case number. This kind of a campaign was undertaken by some of our own members, misleading, misguiding, misrepresenting, rather cheating, creating doubts in the minds of our members. That's the reason. Not only this, I will show you another case also where we have filed. Another 2 cases we have filed, writ petitions claiming this. And this is filed before Bombay High Court. Bombay High Court. Why we filed before Bombay High Court? Their judgment, case comes up before 2 judge bench. Thereby, we are cutting down the time. Okay? In addition to this, what we have done is, now both before Bombay High Court and Karnataka High Court, we have filed interlocutory application stating that Supreme Court has decided this issue already. Whatever we are claiming in writ petition, it is already decided by Supreme Court. Supreme Court in contempt order, it is clearly stated that if you are not, if the judgment is not implemented, you file appropriate proceedings for getting the order implemented. Since this issue is already decided, please implement the order of Supreme Court. We have filed interlocutory application. In all probability, we have made efforts for listing of the case during this week. In case if it is listed, shortly we must get one order early. Okay, but we don't know what is going to happen. Okay, we engage, senior advocate appearing us, getting 1,50,000 rupees, appeared 3 times, it did not go beyond 1 or 2 minutes. Okay, so there are a lot of problems in judiciary and judicial system. We need to overcome that. Okay, so this is what we are doing it. Now, we have for implementation, case writ petition for implementation, we have filing case before Delhi High Court. We cannot file before any other court because we have to get the order of Delhi High Court implemented. We are unfortunately till 14th only reopened after vacation. First week was hectic for our advocate. Fortunately, Mr. Shekhar J. Devasa, who had come to attend our Mysore Bank Foundation Day function last year, he is the senior advocate now. Both Supreme Court and Delhi High Court reopened on 14. You know, all the important cases which are pending during vacation, they have to be filed. He was busy. Yesterday evening also I have spoken to him. He said he has promised me that he is going to file case during this week. It will not take years. Because when we filed the case for implementation earlier, it was disposed of in 46 days. Okay? 46 days. Even now, I do not expect much of time. And to cut down the time, what we are doing now, we are not filing case against all other banks. We are filing case against Government of India. Union of India is the first respondent. State Bank of India is the second respondent, and Indian Banks Association is the third respondent. Why we are bringing in Indian Banks Association is that in 2012, when we won the case in Karnataka High Court, State Bank of India referred the matter to Indian Banks Association. Incidentally, Indian Banks Association is one of the respondents in our Supreme Court case also. State Bank of India and all associate banks were also parties in our civil appeal in Supreme Court also. So when State Bank of India asked Indian Banks Association, Indian Banks Association has clearly advised State Bank of India that judgment of Karnataka High Court has got implication on all the banks which are parties to bipartite settlement. That means Indian Banks Association itself has stated Karnataka High Court judgment is binding on all the banks. That means including State Bank of India. Now we are producing that letter to the court. Now Indian Banks Association cannot say anything else. Letter I have showed, State Bank of India has said that we are paying DMS relief in terms of Regulation 37. Okay, has been paid. So State Bank of India cannot say anything else now. Added to that, okay, I will read. What is the judgment in Karnataka High Court? It is very important. Please, I will also read from that. Let nobody have any doubt about our claim. And a lot of people say, we have already received DA, on that, how can we get DA on that amount? Okay? I will read from the judgment. That is only operating portion of the judgment. These officers/petitioners are not stopped from availing the benefits contained in the Pension Regulation 1995 in spite of availing the benefit of ex gratia payment and better pay scales contained in the joint note dated 14/12/1999. Means what? My pay might have been increased on account of my joint note, but pension is required to be paid in terms of pension regulation. Not only that, what they have stated, please listen. Accordingly, writ appeals are dismissed. Writ appeals filed by banks including State Bank of Mysore was dismissed. Since Pension Regulation 1995 have not at all been amended by the State Bank of Mysore, its appeals are bereft altogether of any merit. High Court has said State Bank of Mysore is not even entitled to file an appeal. Since you have filed the appeal, must be held liable to pay cost of rupees 10,000 to each of their former employees petitioners. 615 ಜನಕ್ಕೆ 10,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಅನ್ನ ಸ್ಟೇಟ್ ಬ್ಯಾಂಕ್ ಆಫ್ ಮೈಸೂರು ಪೆನ್ಷನರ್ಸ್ ಕಮ್ಯುನಿಟಿ ಕೊಡಿಸಿದೆ. 10,000 rupees, each of them have got 10,000 rupees. 61,50,000 rupees has been paid in addition to arrears. Sad to tell you, sad to share, a large number of them, after receiving 10,000 rupees extra, they did not pay even 1 rupee after having received. Okay? We have got names. Now, what action we need to take, we will take. This is division bench. Now, I will read from the single judge bench. Okay. You can see my name. I am also one of the petitioners here. Okay. Petitioners are entitled to payment of pension. I will come to this. In terms of Chapter 6 of the State Bank of Mysore Employees Pension Regulation 1995. What do you mean by Chapter 6? What are the regulations that are there in Chapter 6? I will go to Supreme Court judgment which upheld there. They have extracted these regulations. If the Supreme Court, Bank of Baroda was on another. Here, Civil Appeal 1919 is that of State Bank of Mysore. You can see here, judgment of 4178, 4183, State Bank of Mysore versus K. Sushila. You can see State Bank of Mysore name is there. List of cases is there. Can you see Regulation 37? Kanisthidya? Can you see Regulation 37? Dearness relief shall be granted on basic pension or family pension or invalid pension or on compassionate allowance in accordance with rates specified in Appendix 2. Dearness relief shall be allowed on full basic pension even after commutation. We are asking for pension in terms of this judgment. Have you got this judgment regarding Regulation 37? Yes, okay. Now, what is there in Appendix 2? Our website has got our pension regulation. Please download and keep it. It remains at that. Why? Because our pension regulation and Provident Fund rules are framed under Subsidiary Banks Act. In 2019-18, Government of India has repealed State Bank of India Subsidiary Act. That means State Bank of India cannot carry out any amendment to our regulation. Why? Because the act which gives them power is not in existence. Now Government of India should revise the act, then give the authority to State Bank of India to amend. Please understand the difficulty in getting our benefits altered or taken away. Okay. Another important one, a lot of people have got this question. Why? Whether it involves so much of money, will they give? So much of money, if will they give? Whether the court permits. One, then Anyaya. There are two judgments. One is Raghunath Rai Bareja versus Punjab National Bank. What happened in this case is, a guarantor did not repay the loan. Then he went to Supreme Court. Supreme Court said that if any loan is taken, it has to be repaid. If it is not repaid, guarantor should repay. If guarantor, therefore, equity is with the bank. That means, Nyaya bankina jote ide. Next they say, we must however state that it is well settled that when there is a conflict between law and equity, ಕಾನೂನು ಮತ್ತು ನ್ಯಾಯ ಮಧ್ಯೆ ಘರ್ಷಣೆ ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ, it is the law which has to prevail. ಕಾನೂನು ನ್ಯಾಯಕ್ಕಿಂತ ಮೇಲ್ಪಡುತ್ತೆ. In accordance with Latin maxim, dura lex sed lex, which means the law is hard, but it is the law. Equity can only supplement the law, but it cannot supplant or override it. Next, in the same judgment, it is also quoted, in case where statutory provision is plain and unambiguous, the court shall not interpret the same in a different manner only because of harsh consequences arising therefrom. Harsh consequences ಅಂದ್ರೆ ಸಾವಿರಾರು ಕೋಟಿ ರೂಪಾಯಿಗಳು ಕೊಡಬೇಕಾಗುತ್ತೆ. ಸಾವಿರಾರು ಕೋಟಿ ರೂಪಾಯಿ ಕೊಡಬೇಕಾಗುತ್ತೆ ಅಂತ ಕಾನೂನಿನ ವಿರುದ್ಧವಾಗಿ ಕೋರ್ಟ್ಗಳಿಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಲಿಕ್ಕೆ ಅಧಿಕಾರ ಇಲ್ಲ. ಓಕೆ. From the words of law, there must be no departure. A result flowing from a statutory provision is never an evil. A court has no power to ignore that provision to relieve what it considers a distress resulting from its operation. A statute must of course be given effect to whether a court likes the result or not. In view of the above, it becomes crystal clear that under the grab of interpreting the provision, court does not have power to add or subtract even a single word, as it would not amount to interpretation but legislation. ಕಾನೂನು ನಮ್ಮ ಕಡೆ ಇದೆ. If anybody has got doubt regarding law, please come to office. I have extracted the judgments. I have got 100-page extraction of the judgments. Every ground you raise, I am replying with a judgment. How we can do it? We are proud. We are the only organization, perhaps retiree organization, which has subscribed to SEC online. We do research whenever any ground comes. If I have to file a case, for example that commutation case or special allowance case, what we do is we do reverse. What are the grounds bank can raise? How to counter it? How to overcome it? We do devil's advocate. I know two judgments regarding this DA. One judgment is already referred, Menon. There is one more judgment. There, what they say is, because of provision in regulation, you cannot claim. But unfortunately for the bank, their claim is rejected, not maintainable, because this benefit is already there in another government order. The provision is already made on account of law. Therefore, that was rejected. In our case, there is no such thing. And remember, Karnataka High Court has already said that even a settlement cannot take away, referring to Mangalore City Corporation versus NS Giri, it has also decided even a settlement in terms of Industrial Disputes Act cannot take away any benefit that is available in our regulations. Understood? Okay. Before I again revisit, I have got some request from you. What we have found is, most of you who have retired after 2020, you have not paid legal fees, 5,000 rupees. One-time legal fees. This 5,000 rupees is not only for fighting Regulation 37, you have got several other issues. One more issue that has affected you. All those who have retired from 1/11/2017 and March 2021, banks have recovered commutation. Banks have recovered commutation from the arrears. It is illegal. We have filed case for it. You will get that benefit also. Reserve Bank of India benefit, you will get it. Then State Bank of India is extending full medical benefit to those chief general managers retired from State Bank of India. We have also filed a case seeking full medical benefits to all of us, because bank cannot slice CGM separately from other pensioners. After all, Chief General Manager is also a pensioner of State Bank of India, like all of us. There cannot be two classes of pensioners. Like that, we are fighting for several benefits for you, including Provident Fund. Okay, then we will ensure that henceforth bank does not seek explanation at the age of 95. Okay, so all efforts we are taking. Please pay 5,000 rupees one time. Please pay 5,000 rupees to fight your fight effectively. Please pay 5,000 rupees and strengthen the hands of State Bank of Mysore Pensioners Commune. Okay, right? Debit authorizations are there. Please fill in while leaving. Next, those who are still employees, they can also become member of State Bank of Mysore Pensioners Commune through Mysore Bank Welfare Trust. There is no bar in you becoming a member of Mysore Bank Welfare Trust, which collects 2,500 rupees, and upon death, legal heirs will get 15,000 rupees. We are calling it as Shraddhanjali scheme. It is for a retiree. But for an employee, what we are doing is, we are collecting 4,500 rupees for membership of Mysore Bank Welfare Trust. Upon retirement, what we will do is, we will give a list of those who have tried to damage our organization, damage our cause to the bank. And we tell the bank that we are not representing them in any of these court cases. We will not tell the bank not to pay. We will only tell the bank that we are not representing. The history of State Bank of India says, they dodge even if your name is there. They will dodge even if they try to avoid, even if you have filed the case. If they get this letter, I am sure they are not going to pay. Let them fight on their own. Commune, State Bank Retirees Association or All India Retired Bank Employees Association will not fight for them. But in case if State Bank of India extends benefit to them, then certainly we will demand extension of all the benefits which are paid only to the petitioners. Recent example, Chennai case, one employee had served for 20 years, 1 month. Pension was not paid to her. She is a original SBI employee, pension was not paid to him or her. Then division bench dismissed appeal. Then bank took time to file SLP. In the meantime, she sent a contempt notice. Bank has paid her benefit, but filed an affidavit before Supreme Court that we continue to litigate. Even if she loses the case, we will continue to pay her, but we would like to continue with the case because we want to establish law. They have written this in black and white. It is connected to another case of State Bank of Bikaner and Jaipur, Vandana, out of, that is Bombay High Court, Nagpur bench. There is one more judgment of Kerala High Court, where somebody had served for 19 years, 7 months. 19 years, 7 months, he retired voluntarily, pension was not paid to him, quoting our own State Bank of Patiala case, State Bank of Patiala versus Pritam Singh Bedi, then Indian Bank versus Venkatramani. The court decided he is entitled to pension. State Bank of India has filed appeal in respect of all these cases. They will, even if they win, they will pay only to petitioners, not to others. This is the history of State Bank of India. Okay, so please join and strengthen us. Next, if you are not receiving Shatayu, please send a mail or send WhatsApp on 702-602-7774. We are posting all issues of Shatayu in our website. 13, 14, 15th we are posting. From 2016, all issues of Mysore Bank Shatayu is available in our website. If you have not received anything, please go through. Please, another request, please do not listen, do not read, do not hear anything said in WhatsApp. There are two benefits. One, your life will expand. You will live many more years longer. One. Number two, you will never get disappointed. Okay? You will never get disappointed. Okay? We are not barring anybody from becoming member of State Bank of India Pensioners Association. We know the constitutional right. Anybody can become member of any other organization. We are not saying that you should not become SBI Pensioners Association member, but our only request is please become member of your bank association. Okay? Perhaps State Bank of Mysore Pensioners Commune is the only organization which has made State Bank of India chairman to apologize. We have got the apology from State Bank of India chairman in Supreme Court in our contempt petition. Somebody said they are sending notice. No, we have already got it. Okay? We will again, there might be, why they have not filed still contempt petition for not giving reply in 6 weeks and not calling us for meeting. Deliberately we are not doing, we have not done, because our intention is not to punish anybody. Our intention is to get the benefit. If you play drama in the writ petition, what we file, we are going to file a contempt petition. Because absolute, even Delhi High Court has clearly stated, the main grievance of the petitioners is that they are not made party to joint note, taking away the vested right. That means our grievance is not making us a party. They have not called us for the meeting. Therefore, we are entitled to, everything is in black and white. It is not difficult to prove. I have got all the circulars, all the documents for having conducted this meeting without calling us. We have got time till March. Whenever they conduct any meeting in any LHOs, again we get an opportunity to file contempt petition. It is perennial and permanent. Every time I can file contempt petition. If they continue to face contempt petition twice or thrice, take it from me, chairman will go to, we will file criminal contempt petition. Because it is a deliberate defying of Supreme Court order. Okay? We don't not only bark, we also bite. We are strong enough. State Bank of India, at the instance and instigation of some people, issued notices to vacate. Thanks to Jai Kumar, thanks to State Bank of Mysore, thanks to Jayesha and Sajeev Krishnan, now State Bank of India cannot ask us to vacate the premises. This is what we have done. We have got our credentials with us. Okay, please support us. Our only request, please pay 5,000 rupees for fighting the case. And if we have already invested monies what we have received safely by having Vishranti Graha at Mysore Road. We have invested money. If we have got any small program, I have been telling this, if you have got any small program, suppose if a birthday or naming ceremony or any such program which needs accommodation of about 50-60 people, you can use the hall. You need to pay only 2,500 rupees. We have also got a clubhouse there which can accommodate about 100 people. There also it is only 2,500 rupees half day. You can use these facilities also. Why 2,500? We want you to book all the 5 rooms so that nobody is affected and you are also not disturbed. Take 5 rooms for a day, spend 2,500 rupees, make use of that. Why we bought apartment? Why we did not keep in fixed deposit? We have seen many organizations where monies have vanished. Then properties have been registered in individual names. There is misappropriation. Okay, lot of things have happened. Now we have secured that money. Another intention of buying that apartment is, see, in another 2-3 years' time, retirements would stop completely. Pensioners will not come because there was no recruitment after 1995. Small numbers, okay? Only that temporary employment regularization or such things are there. Thereafter, you will hardly have 2%, 3%. Today, those who are in NPS is already 75%. By 2000, next bipartite settlement, 90% of the employees are in NPS. Okay? So that means only 10% of our people would remain. That means 300, 400, 500 people would be there after that. So our income will not be there. We need money. At such time, we will close down that Vishranti Gruha, give it for rent. At least we will get 1 to 1.5 lakhs as rent, which should be enough for us to run the office. And nobody can sell the property. We have formed 15 trustees trust, where 8 are permanent trustees, 7 are ex officio trustees, 7 are nominated by State Bank of Mysore Pensioners Commune. 8 permanent trustees are all the 4 of us, plus Jayesha, Dr. Lakshmisha, then Siddhagangaya, and our working president Kanastri. What we have done is, if any of us resign or die, we can nominate 1 permanent trustee out of members of State Bank of Mysore Pensioners Commune only. Okay, why we did it? Why not all the 15 from SBM Pensioners Commune? Tomorrow, if there is a team which replaces us, would like to sell off the property, it should not become an easy way out. We have put checks and balances. We will not leave. We want name of State Bank of Mysore to continue, so we will not leave. We will ensure that the property is there. We want our children to use. Okay? Objective is that. Finally, this organization should be carried by next generation also. They should remember you. My grandfather or father was a member of this organization, and he was working for State Bank of Mysore. They have done this. This is our ultimate objective. Okay? Then, in case if everybody decides to sell, 75% of the members present in the general body should agree for selling the property. Our property is safe. There cannot be anything. Your money is safe. Therefore, please strengthen your organization. That's all. If you have got any question, I am prepared to answer.
ಮ್ಯಾರಥಾನ್ ಲೆಕ್ಚರ್ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲರೂ ಎದ್ದು ನಿಂತ್ಕೊಂಡು ಅವರಿಗೆ ಒಂದು ಅಪ್ಲಾಸ್ ಕೊಡಿ.
ಪ್ರಶ್ನೆ ಏನಿದ್ರು ಕೇಳಿ.
ಆತ್ಮೀಯರೇ, ಎಲ್ಲರೂ ಇದುವರೆಗೂ ಶಾಂತವಾಗಿ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದ್ದೀರಾ. ನಿಮ್ಮ ತಾಳ್ಮೆಗೆ ನಮ್ಮ ಕೃತಜ್ಞತೆಗಳಿದೆ. ಎಲ್ಲರೂ ಮಧ್ಯಾಹ್ನ ಊಟ ಮಾಡಿಕೊಂಡು ನಿಧಾನಕ್ಕೆ ನಿಮ್ಮ ಊರಿಗೂ, ಬೇರೆ ಊರಿಂದ ಬಂದಿರೋರಿಗೆ ಸ್ಪೆಷಲ್ ಥ್ಯಾಂಕ್ಸು. ಅವರು ಅಲ್ಲಿ ಹಗರಿಬೊಮ್ಮನಹಳ್ಳಿ ಅಂಥ ಕಡೆಯಿಂದೆಲ್ಲ ಬಂದಿದ್ದೀರಾ, ತುಂಬ ಥ್ಯಾಂಕ್ಸ್. ಚೆನ್ನೈ, ಅವರು ಚೆನ್ನೈಯಿಂದ ನಮ್ಮ, ನೀವು EC ಮೆಂಬರು, ಅವರು ಆರ್ಡಿನರಿ ಮೆಂಬರು. ಓಕೆ.
ಐ ಮಸ್ಟ್ ಥ್ಯಾಂಕ್ ಮಿಸ್ಟರ್ ವಿ ಪ್ರಸಾದ್. ನಮ್ಮವರೇ ಈ ವೆನ್ಯೂ ಸಿಗಲಿಕ್ಕೆ ಮುಖ್ಯ ಕಾರಣರು ಪ್ರಸಾದ್ ಬರಲಿ ಅಂತ ಕಾಯ್ತಿದ್ವಿ, ಬಂದಿಲ್ಲ. ಓಕೆ, ನೆಕ್ಸ್ಟು ಅನಿಲ್ ವಿಶೇಷತೆ ಏನಂದರೆ, ಅನಿಲ್ ಅವ್ರ ತಾಯಿ ನಮ್ಮ ಸದಸ್ಯರು. ಅವರಿಬ್ಬರಿಗೂ ನಾವು ವಂದನೆಗಳನ್ನ ಅರ್ಪಿಸ್ತೇವೆ. ನಾನು ಪ್ರಸಾದನ ಭೇಟಿ ಮಾಡಿದಾಗ ಈ ಜಾಗ ಬೇಕು ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು, ಇದು BMS ಅಲ್ಲೂ SBM ಇದೆ ಅಂತ, ನೀವು ಉಲ್ಟಾ ಮಾಡಿ BMS SBM ಆಗುತ್ತೆ, SBM BMS ಆಗುತ್ತೆ ಅಂತ. ಥ್ಯಾಂಕ್ ಯು. ಬರಲಿಲ್ಲ. ಅನಿಲ್ ಕಾಣಿಸ್ಲಿಲ್ಲ. ಎಲ್ಲರೂ ನಿಧಾನವಾಗಿ ತಗೊಳ್ಳಿ, ಸ್ವಲ್ಪ ನಿಧಾನ ಆಗುತ್ತೆ, ನಿಧಾನವಾಗಿ ತಗೊಳ್ಳಿ. ಏನಾದ್ರು ಪ್ರಶ್ನೆ ಸರ್?
ಯೂಟ್ಯೂಬ್ ನಡೀತಾ ಇತ್ತಾ? ಇಲ್ಲ, ನೋಡಿದೆ ನಾನು, ಸ್ವಲ್ಪ ನೋಡಿದೆ.
ನೋಡ್ತಾ ಇದ್ದಾರೆ, ತುಂಬಾ ಜನ ನೋಡ್ತಾ ಇದ್ದಾರೆ.
ಬರೋರಲ್ಲಮ್ಮ
ಯೂಟ್ಯೂಬ್
ಯೂಟ್ಯೂಬ್ ಇದ್ದಕ್ಕೆ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ.